on why your business needs to protect its IP, with this webinar focusing on intellectual property protection. My name is Talia and I'm an intellectual property lawyer at LegalVision, and I help all kinds of businesses from startups to established businesses in developing and protecting their intellectual property. Who is LegalVision? LegalVision is a tech-driven full-service law firm that uses technology to deliver a faster and more cost-effective client experience. We were recently named the fastest growing law firm in the Asia Pacific by the Financial Times. We are a dedicated commercial law firm with expertise in intellectual property, general commercial law, disputes, corporate law, and franchising. This means that we can help businesses with a wide range of their legal needs, whether that means applying to register a trademark or even raising capital. In the first webinar, we had a look at the landscape of intellectual property in Australia, including what IP actually is and what you can recognise within your business as an IP asset. Today, we'll take a closer look at how you can actually protect your intellectual property. We've already discussed what intellectual property is, so now we'll look at how you can protect it. We'll be focusing on three key aspects in this webinar: the best methods to protect your intellectual property and the benefits of protection, the steps for registration of certain intellectual property rights, and also what steps you can take if somebody infringes your intellectual property. We'll also have a look at another important IP case so you can see IP rights in action. As a reminder of where we started, we looked at the forms of IP with a specific focus on trademarks. I think it is important to have a deep dive into trademarks, considering they are the most well-known and often the most common form of registered IP right. In the first webinar, we looked at the development stages of trademarks, thinking about branding that is unique and something which your customers can use to differentiate your business from that of your competitors. Once you have your proposed trademark developed, we can then begin looking at the protection of trademarks. In the first webinar, we touched on the governing body for registrable IP rights in Australia, IP Australia. IP Australia will manage all applications for anything from trademarks, patents, designs, and plants breeders' rights. In this second webinar, we'll focus on how to protect your IP rights within the particular registration through IP Australia, as well as other non-registerable methods. In the first webinar, we looked at the IP rights which can be registered, patents, designs, and trademarks. Today, we're going to focus on trademarks, as trademarks are the most popular and common types of IP. You can apply for a trademark both domestically and internationally. So the domestic approach, we'll look at Australia. To file an application in Australia, you must follow some clear steps. The first is to file an initial trademark application in relation to the specific goods and services that you actually provide and how the trademark will be owned. Following that, you will receive a first examination from IP Australia, and this will set out any specific issues identified in your application. If there are no further issues in your application, you'll proceed to the advertisement and opposition period. So once it has been examined for 5 months, it will enter the 2-month opposition period. This is where any interested third parties may oppose your trademark application. It is relatively uncommon, however, for an opposition to occur, although it is important to seek advice if your trademark is opposed. Following this, provided no one opposes your mark, you will proceed to registration, where your mark is registered for 10 years. Sometimes though, there can be extra steps in the process if IP Australia do raise an objection to your application. That comes in the form of an adverse report. If your first examination report does raise specific issues, you will generally have a 15-month period in an attempt to overcome the issues raised. Depending on the particular concern raised by IP Australia, we can certainly guide you through to develop the most appropriate strategy to attempt to achieve registration. As Australian businesses continue to expand into international markets, you may also consider protecting your branding internationally. There are 2 distinct ways to apply to register your trademark internationally. The first is through a direct application. If you want to register in 1 or 2 specific countries, you can apply to register your trademark directly with the country's specific intellectual property office. This is called a direct application. For example, if you only wanted to register in the US, we would apply directly to the US Patent and Trademark Office. Alternatively, if you wish to register in multiple countries, the most cost-effective and efficient method is to apply through the World Intellectual Property Organization. We would generally prepare one application and nominate a wide range of countries, such as, for example, the UK, Canada, and even the European Union. The approach you choose for international registration does depend on how many countries you will apply for and also what your specific international expansion plans are. Let's have a look at a case involving the tech giant Apple. This case is perhaps a little less known than the Hungry Jack's case we discussed in the first webinar. However, it is an interesting insight into trademark registration internationally. This case was about a trademark dispute over the ownership of the mark iPad in China. When Apple released the iPad, you'd be forgiven for thinking they had all the I's dotted and crossed the T's with relation to their branding. However, this was not the case. They had actually not yet secured the right to the mark iPad in China. A company Apple had previously worked with took the opportunity to register the trademark for iPad before Apple was able to do so. This has led to a lengthy legal battle, which was ultimately settled by Apple for a hefty $60 million. In China, registering your trademark quickly is very important because China's first to file intellectual property laws mean that the person or business to file their trademark application first is generally granted the right to that trademark. Even though we've touched on a very large company attempting to secure a trademark right, the learnings from this case are not limited to multi-billion-dollar businesses. The key takeaway from both this case and the infamous Hungry Jack's case is to protect your intellectual property, protect it early, and ensure you have appropriate contracts in place with all contractors, employees, and businesses you work with. So this leads us to the next important question: how should you protect your intellectual property? As we discussed in the first webinar, whilst there are a number of IP rights you can specifically register, there are some IP rights that are not registrable. Luckily, there are other ways to protect your valuable IP. Depending on what industry your business operates in, you will likely use a range of contracts. These can include anything from the sales terms and conditions between yourself and your customers, contracts such as distribution agreements, and contracts used in everyday business transactions. Often you can also use these same contracts to assist you in protecting your intellectual property. So if you have employees, they can sometimes develop intellectual property in the course of their employment. Undoubtedly, you'll want to own some, if not all, of the IP they develop. If this is the case, it is vital that your employment agreements specify that if intellectual property is developed throughout the course of employment, your business will own all the rights to it. Similarly, if you engage contractors, you should set out the arrangement in the form of a contract. This is important for several reasons. It ensures that both you and your contractor agree on payment terms, the scope of work to be performed, and again, that any intellectual property the contractor develops whilst engaged with your business will be owned by you. A contract is also vital if you manufacture your own products, purchase your products direct from manufacturer, or use distributors for your products. Any product may feature a trademark, design right, or a patent, and you'll need to confirm what elements of the intellectual property you own. If you use a manufacturer to produce your products, your contract should set out whether the manufacturing process is something unique that you have developed and how elements of your branding may be used. If you use a distributor, it should be clear that you retain all IP associated with distributed products. Although formal contracts may seem daunting, there are many reasons why you should ensure that any business relationship is governed by a contract. Protecting your IP is just one reason. If your business IP has been infringed, or if you are concerned that it will be infringed, you might consider engaging the services of an IP monitor. Monitoring generally includes monitoring the various IP government registered in Australia, as well as more general monitoring. This can include searching business name and ABN registers and social media platforms, among others. Monitoring allows you to find out quickly if there are third parties infringing on your rights. This gives you the advantage of being able to decide whether you wish to pursue the infringers before they cause any significant financial or reputational damage to your business. Monitoring also allows you to keep up to date on whether there are any applications being processed by IP Australia which you may wish to oppose. If IP Australia does not itself object to the application, but you believe that it is likely to infringe your existing rights, you can oppose the application. There is a limited period during which You can oppose the application for registered right. As mentioned before, it's usually 2 months. So IP monitoring is often the most effective way to keep up to date. Once you own an IP right, it is important you make this very clear. This can be confirmed within contracts that you prepare or simply through adding the appropriate registered symbol, such as the copyright symbol and the registered symbol for trademarks. Even though the symbol TM does not carry any specific protections, many businesses will use this symbol to deter others from using their IP. Making it clear that your IP is owned and therefore protected is often a good deterrent for third parties not to infringe your rights. So why protect your rights? There are many reasons why you might choose to protect your IP rights. Some key benefits of protection include ease of enforcement against potential infringers, also a higher business valuation with your IP recognised as a tangible asset, exclusive use of the IP, generation of royalties, especially if you license your IP, the promotion and recognition of your branding, and potential collateral to obtain finance, and also greater export options. If you do not seek to protect your IP rights, it may become increasingly difficult to enforce them. In the long run, it can be extremely expensive to enforce unprotected rights. It is also more complex from a legal perspective to attempt to enforce unprotected IP rights against a potential infringer. To reduce the risk of a costly and difficult enforcement exercise down the track, we always recommend protecting your rights as early as possible. Once you have decided to protect your rights, you should decide on a protection strategy. It's a good idea to develop a clear IP protection strategy with the assistance of an experienced legal team. When we develop a protection strategy for our clients, we consider what IP assets the client has and what aspect of that IP we can protect. As part of this strategy, we consider what IP rights are most valuable and how we can enforce these rights in the future. A protection strategy is a great starting point for any business that might be unsure about where to begin with securing IP protection, or any business who has already developed a portfolio of IP rights. It's never too early or too late to consider IP protection. So, in this webinar, we've now covered how you can protect your IP and why you might want to. Before we finish up, let's discuss where you can go from here. First, it's important to recognise the valuable nature of IP assets, and second, understand how best to protect these assets. Although we recognise there are often upfront costs involved in securing protection of your IP, the cost of seeking protection ultimately pays for itself in the long term. This is especially the case if you need to enforce your IP rights against infringers or have your business valued. Your business needs to protect its IP so that competitors do not use your IP for their own advantage, and to ensure your business retains the value of the IP. Most importantly, as we've said, we recommend seeking to protect your IP early and broadly. If you would like to understand more about what valuable IP assets you may have, or if you are keen to move forward with protection, LegalVision team of experienced property lawyers can help you get started. As a full-service commercial law firm, LegalVision can assist with all aspects of your business's legal needs. We have a dedicated IP team who regularly assist business with protection strategies, registering IP rights, and if necessary, enforcing these rights. If you have invested time, energy, and capital in your business, you should have a dedicated and enthusiastic legal team to protect those investments. Here at LegalVision, we are passionate about our clients and committed to the success of their businesses.